Hello students, in this lecture we're going to start with the bailment and pledge. So let's begin. So at the very offset, I would like to discuss with you this question that has been asked in UPPC's examination of 1992. Write short notes on bailment and pledge. Now by the time that we're done with this topic, you will be easily able to answer this question. So, what is bailment? Bailment actually implies a sort of relationship in which the personal property of one person temporarily goes into the possession of another. The ownership of the articles or goods is in one person and the possession is in another. So, bailment has been defined in Section 148 of Indian Contract Act, as we know. It says bailment, bailer, and bailee defined. A bailment is the delivery of goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. The person delivering the goods is called the bailer, the person to whom they are delivered is called the bailee. It has an explanation that if a person already in possession of the goods of another contracts to hold them as a bailee, he thereby becomes the bailee and the owner becomes the bailer of such goods, although they may not have been delivered by way of bailment. Now, there are certain essential features of bailment which we are going to emphasize upon now because it is something very fundamental and can be asked as a question. So, at the very start, I would like to discuss with you the idea of delivery of possession, which is the first most essential of bailment. So, what is delivery of possession? As held in Reeves versus Capper, delivery of possession for this given purpose should be distinguished from a mere custody. One who has custody without possession, like a servant or a guest using his host's good, is not a bailee. The goods must be handed over to the bailee for whatever is the purpose of bailment. And once this is done, a bailment arises irrespective of the manner in which this happens. In Ulzen versus Nichols, where an old customer went into a restaurant for the purpose of dining there, and when he entered the room, a waiter took his coat without being asked and hung it on a hook behind him. And when the customer rose to leave, the coat was gone. So, here, what the waiter did might be no more than an act of voluntary courtesy towards the customer. Yet, the restaurant keeper was held liable as a bailee. The waiter, by taking the coat into his possession, had relieved the plaintiff of its care and had thus assumed the responsibility of a bailee. It was he who selected the place where the coat should be put. Now we see that there is the idea of actual delivery or constructive delivery. So, Section 149 mentions that delivery to bailee how made. The delivery to the bailee may be made by doing anything which has the effect of putting the goods in the possession of the intended bailee or of any person authorized to hold them on his behalf. An explanation to Section 148 provides that if a person already in possession of the goods of another contracts to hold them as a bailee, he thereby becomes the bailee and the owner becomes the bailer, although they may not have been delivered by way of bailment. So, delivery of possession is thus of two kinds: actual delivery and constructive delivery. When the bailer hands over to the bailee physical possession of the goods, that is called actual delivery. And constructive delivery takes place when there is no change of physical possession, goods remaining where they are, but something is done which has the effect of putting them in the possession of the bailee. For example, in the case of Murvi Mercantile Bank versus Union of India, where delivery of a railway receipt amounted to delivery of the goods. Another illustration of constructive delivery is in the case of Fazil versus Salamat Rai. Here, the defendant was holding the plaintiff's mare under the execution of a decree. The plaintiff satisfied the decree and the court ordered re-delivery of the mare to the plaintiff. The defendant, however, refused to do so unless his maintenance charges were also paid. So the mare was stolen from his custody. And holding him liable, the court said that after the delivery order had been passed, the relation of bailer and bailee was established by virtue of the explanation to Section 148. Now, the second essential is that delivery should be upon contract. Yes, delivery of goods should be made for some purpose and upon a contract that when the purpose is accomplished, the goods shall be returned to the bailer. When a person's goods go into the possession of another without any contract, then there is no bailment within the meaning of this given definition in Section 148. And a well-known illustration is the decision of Ram Gulam versus Government of UP. Here, the plaintiff's ornaments, having been stolen, were recovered by the police and, while in police custody, were stolen again. So the plaintiff's action against the state for the loss was dismissed. And while dismissing it, Justice Seth said that the obligation of a bailee is a contractual obligation and springs only from the contract of bailment. It cannot arise independently of a contract, and in this case, the ornaments were not made over to the government under any contract whatsoever. The government, therefore, never occupied the position of bailee and was not liable not liable to indemnify the plaintiffs. Now, talking about non contractual bailments, we see that English law recognizes bailment without contract. In the words of Cheshire and Freefoot, at the present day, no doubt in most instances where goods are lent or hired or deposited for safe custody or as security for a debt, the delivery will be the result of a contract. But this ingredient, though usual, is not essential. The Bombay High Court, in its decision in the case of Lasalgaon Merchants Corporation Bank Limited versus Prabhudas Hathibhai, has taken the lead in imposing the obligation of a bailee without a contract. In the opinion of the court, as expressed through Justice Nayak, where certain goods belonging to an individual are seized by the government, then the latter becomes the bailee thereof, even if there is no suggestion of a contract between the government and the individual. The facts of this case were such that certain packages of tobacco lying on in the godown of a partnership firm were pledged to the plaintiff bank, and some of the partners, having failed to clear their income tax dues, the income tax officer ordered seizure of the goods. The officials in this case accordingly locked the godown and handed over the over the key to the police. So then came heavy rains and the roof of the godown leaked and the tobacco was damaged. So in this case, the court said that heavy rains do not necessarily amount to an act of God. It was the duty of government officers to take such care as every prudent manager would take of his own goods. The government stood in the position of bailies, and it was for them to prove that they had taken as much care as was reasonably possible for them and that the damage was due to reasons beyond their control. Now, this view has also been accepted by the Supreme Court in the case of State of Gujarat versus Memon Muhammad Haji Hassan. Here, certain motor vehicles and other goods belonging to the plaintiffs were seized by the state in exercise of its power under C Customs Act, and the goods, while in the custody of the state, remained totally uncared for. So it was contended on behalf of the state that as the state were not bailies, there was no obligation to take care of. But referring to this given idea, Justice Sheleth observed that this given contention is not sustainable because bailment is dealt with the Contract Act only in cases where it arises from a contract. But it is not correct to say that there cannot be a bailment without an enforceable contract, nor is consent indispensable for such a relationship to arise. And a finder of goods of another has been held to be a bailee in certain circumstances. The court also went on to cite this given passage from Pollock and Wright that bailment is a relationship sui generis, and unless it is sought to increase or diminish the burdens imposed upon the bailee by the very act of bailment, it is not necessary to incorporate it into the law of contract and to prove a consideration. Also, the contract may be express or implied, and as held in Journal of India in Council versus Jubilee Mills Limited, where with the consent of the station master, goods were stored on a railway company's platform and wagons being not available, the company was held liable when they damaged by. Also, the contract may be express or implied. Thus, in the case of Governor General of India and Council versus Jubilee Mills Limited, where with the consent of the station master, goods were stored on a railway company's platform, wagons being not available, the company was held liable when they were damaged by fire caused by a spark emitted by a passing engine. Now, the third essential is that delivery should be upon some purpose. As held in Gangaram versus Crown, bailment of goods is always made for some purpose and it's subject to the condition that when the purpose is accomplished, the goods will be returned to the bailer or disposed of according to his mandate. Now, at the same time, bailment has been compared with other similar relations. So, on that note, it is clear. Now, bailment has also been compared with other similar relations. It is important to clear the same. So it is this given feature of bailment which distinguishes it from many other transactions of the same kind. That also in the case of Icha Dhanji versus Natha, it has been held that a deposit of money with a banker is not a bailment, as he is not bound to return the same notes and coins. And accordingly, in Union of Bank of India versus KV Vengolupalan, where a bank was not allowed to exercise the right of lien as a bailee of money held under a fixed deposit. So, with such cases, we can see that how similar and yet different bailment is to other similar relations. Further, in the words of Justice Shetty of the Supreme Court in the case of UCO Bank versus Hemchandra Sarkar, one important distinguishing feature between agency and bailment is that the bailee does not represent the bailer, which is not true for agency, as we all know. He merely exercises with the leave of the bailer, under contract or otherwise, certain part of the bailer in respect of his property, and secondly, the bailee has no power to make contracts on bailer's behalf, nor can he make the bailer liable simply as bailee for any act he does. And applying this principle to the position of a banker who was holding the goods on behalf of its account holder for the purpose of delivering them to his customers against payment, the court held that the bank was not thereby constituted into an agent and remained a bailee only. Further, a bailment is also distinguishable from sale, exchange, or any other barter. Because in these transactions, what is transferred is not mere possession but also ownership, and therefore the person buying is under no obligation to return. In Kalyani Breweries Limited versus State of West Bengal, in a sale of beer bottles, one of the terms was that the price of the bottles would be refunded on the buyer returning the bottles. So the transaction here was held to be a sale of the bottles and not a bailment. But as held by the Apex Court in the case of Installment Supply Limited versus Union of India, where a hire purchase contract is a bailment, though of course not merely a bailment. It has two aspects: bailment plus an element of sale. But as held by the Apex Court in the case of Installment Supply versus Union of India, a hire purchase contract is a bailment, though of course not merely a bailment. It has two aspects: bailment plus an element of sale. Now, talking about duty of bailer, which again forms one of the most important parts under this given broad topic. So, according to section 150, which deals with the duty of bailer, bailers are of two kinds, namely gratuitous bailer and bailer for reward. A person who lends his articles or goods without any charge is called a gratuitous bailer. His duty is naturally much less than that of a bailer for hire or consideration. So, what is the duty of gratuitous bailer? The section 150 says that bailer's duty to disclose false in goods bailed. The bailer is bound to disclose to the bailee faults in the goods bailed of which the bailer is aware and which materially interfere with the use of them or expose the bailee to extraordinary risks, and if he does not make such disclosure, he is responsible for damage arising to the bailee directly from such faults. If the goods are bailed for hire, the bailer is responsible for such damage which whether he was or was not aware of the existence of such faults in the goods bailed. So it has illustrations. A lends a horse which he knows to be vicious to B. He does not disclose the fact that the horse is vicious. The horse runs away. B is thrown and injured. A is responsible to B for damage sustained. A hires a carriage of B. The carriage is unsafe though B is not aware of it, and A is injured. B is responsible to A for the injury. So, as seen in Blakemore versus Bristol and Exeter Railway, where a person who lends his horse or horse to a who lends his cycle or horse to a friend, knowing that cycle is without brakes or the house horse is unsound, should disclose this fact, and his duty ends there. Would it not be monstrous to hold that if the owner of a horse, knowing it to be vicious and unmanageable, should lend it to one who is ignorant of its bad qualities and conceal them from him, and the rider, using ordinary care and skill, is thrown from it and injured, he should not be responsible. So, by the necessarily implied purpose of the loan, a duty is contracted towards the borrower not to conceal from him those facts, those defects known to the lender which may make the loan perilous or unprofitable to him. The conditions of his liability are that he should have knowledge of the defect and the bailee should not be aware. and that the defect in the goods must be such as exposes the bailee to extraordinary risks or materially interferes in the use of the goods. Now, what is the duty of bailer for reward? So, the duty of bailer for consideration is much greater. He is making profit from his profession, and therefore, it is his duty to see that the goods which he delivers are reasonably safe for the purpose of the bailment. It is no defense for him to say that he was not aware of the defect. Section 150 clearly says that if the goods are bailed for hire, the bailer is responsible for such damage, whether he was or was not aware of such faults in the goods bailed. He has to examine the goods and remove such defects as reasonable examination would have disclosed. In Hyman and Wife versus Nye and Sons, whereby the plaintiff hired from the defendant for a specific journey a carriage, a pair of horses, and a driver. During the journey, a bolt in the underpart of the carriage broke, the splinter bar became displaced, the carriage was upset, and the plaintiff injured. So, holding the defendant liable, Justice Lindley said that a person who lets out carriages is not responsible for all defects, discoverable or not. He is not an insurer against all defects, but he is an insurer against all the defects which care and skill can guard against. His duty is to supply a carriage as fit for the purpose for which it is hired, as care and skill can render it. Now, talking about duties of bailee, we see that number one duty of bailee is that of reasonable care. Section 151 says that care to be taken by bailee. In all cases of bailment, the bailee is bound to take as much care of the goods bailed to him as a man of ordinary prudence would. Under similar circumstances, take of his goods of the same bulk, quality, and value as the goods bailed. Now, there is this idea of uniform standard of care that you need to know about, students. In India, Section 151 prescribes a uniform standard of care in all cases of bailment, that is, a degree of care which a man of ordinary prudence would take of his own goods of the same time and under of the same type and under similar circumstances. And if the care devoted by the bailee falls below the standard, then he will be liable for loss of or damage to the goods. Further, Section 152 says that bailee, when not liable for loss, etc., of thing bailed. The bailee, on the absence of any special contract, is not responsible for the loss, destruction, or deterioration of the thing bailed if he has taken the amount of care of it described in Section 151. Further, as held in Shantilal versus Tarachand Madan Gopal, no cast iron standard can be laid down for the measure of care due from a bailee, and the nature and amount of care must vary with the posture of each case. On the idea of burden of proof, we see that the burden of proof is on the bailee to show that he was exercising reasonable care, and if he can prove this, then he will not be liable. As held in Katappa versus State of Kerala, if the bailee places before the court evidence to show that he had taken reasonable care to avoid damage which was reasonable foreseeable, or had taken all reasonable precautions to obviate risks which were reasonably apprehended, he would be absolved of his liability. Now, what about cases where the loss is due to act of bailee servant? So, where the loss has been due to the act of the bailee servant, he would be liable if the servant's act is within the scope of his employment. Explaining the principle in Cheshire versus Bailey, Lord Learned Judge Collins said that the bailee is bound to bring reasonable care to the execution of every part of the duty accepted. He may perform that duty by servant or personally, and if he employs servants, he is as much responsible for all acts done by them within the scope of their employment. Now, what about the cases when bailie's own goods are lost with those of bailer? So, for that we have the authority of in Calcutta Credit Corporation versus Prince Peter. We see that where the bailie's own goods were lost along with those of the bailer, it is held that the bailee would naturally contend that he was taking as much care of the bailer's good as he did of his own. But this would not be the deciding factor. The fact that the bailee is generally negligent with his own goods is no justification for his negligence towards the bailer's goods. So, unless the bailer is aware of his habits and therefore knew what to expect, even in such cases, the proper inquiry is whether reasonable care has been taken or not. A person who has come into possession of a chattel through no act of his own and without his consent is called an involuntary bailee. and an early illustration is to be found in the Facts of Harvard versus Harris, whereby the author of a play, without being asked, sent his manuscript to a theatre operator who lost it. The court held that no duty of any kind was cast on the defendant by receipt of something that he had not asked for. Subsequent decisions, however, do not support this view of the situation, and this is amply shown by the case of Newman versus Bond and Hollingsworth. Here, the plaintiff went to the defendant's shop to buy a coat. She was wearing a coat fastened with a diamond brooch, and she took the coat off and put it on a glass case with the brooch by the side of it. When leaving, she forgot the brooch, and it was handed by an assistant to the shop worker who put it in his desk, from where it was lost. In this case, the defendant was held liable. He had not exercised that degree of care which was due from one who had found an article and had assumed possession of it. The degree of negligence must be measured by the apparent value of the article too. But as laid down in Elvin and Paul Limited versus Plummer Radis Limited, if an involuntary bailee without negligence does something which results in the loss of the property, then he will not be liable for conversion. Now, the second duty of the bailee is not to make unauthorized use. Section 154 says that liability of bailee making unauthorized use of goods bailed. If the bailee makes any use of the goods bailed which is not according to the conditions of the bailment, then he is liable to make compensation to the bailer for any damage arising to the goods from or during such use of them. It has certain illustrations where A lends a horse to B for his own riding only. B allows C, a member of his family, to ride the horse. C rides with care, but the horse accidentally falls and is injured. B is liable to make compensation to A for the injury done to the horse. A hires a horse in Calcutta from B expressly to march to Benares. A rides with due care but marches to Cuttack instead. The horse accidentally falls and it is injured. A is liable to make compensation to B for the injury to the horse. So goods must be used by the bailee strictly for the purpose for which they have been bailed to him. Any unauthorized use of the goods would make the bailee absolutely liable for any loss of or damage to the goods. Even an act of God, for that matter, or an inevitable accident would be no defense. A horse lent for riding should not be used for any other purpose, and if it is used outside the scope of the bailment, then the bailee would be liable for any damage to the horse, howsoever happening. Apart from this, the bailer may terminate the contract at once and insist on the goods being returned to him. And this is so provided in section 153. Further, in Alias versus E.M. Patil, where a vehicle was delivered to a workshop for repair and the owner of the workshop allowed an unlicensed employee to drive the vehicle and he caused an accident resulting in the death of a person, it was held that the bailee was liable to compensate the deceased as also the owner of the vehicle because it was an unauthorized use of the vehicle and the liability was absolute. The insurer was also liable to pay compensation to the deceased and recover indemnity from the vehicle owner. Now, Section 153 says that termination of bailment by Bailey's Act inconsistent with conditions. A contract of bailment is avoidable at the option of the bailer if the bailee does not act with regard to the goods bailed inconsistent with the conditions of the bailment. It has an illustration that says that A lets to B for hire a horse for his own riding, B drives the horse in his own carriage. This is at the option of a termination of the bailment. Now, coming to the third duty, which is to not mix. Yes, the bailee should maintain the separate identity of the bailer's goods. He should not mix his own goods with those of the bailer and without his consent. If the goods are so mixed with the consent of the bailer, both will have a proportionate interest in the mixture thus produced. If the mixture is made without bailer's consent, then if the goods can be separated or divided, the bailee is bound to bear the expenses of separation as well as any damage arising from the mixture. But if the mixture is beyond separation, then the bailee must compensate the bailer for his loss. Section 55 to section 57 say the same. Effect of mixture with bailer's consent of his own goods with bailey's. If the bailee with the consent of the bailer mixes the goods of the bailer with his own goods, the bailer and the bailee shall have an interest in proportion to their respective shares in the mixture thus produced. Effect of mixture without bailer's consent and the goods can be separated. If the bailee, without the consent of the bailor, mixes the goods of the bailor with his own goods and the goods can be separated or divided, the property in the goods remains in the parties respectively. But the bailee is bound to bear the expense of separation or division and any damage arising from the mixture. Now, it has an illustration, section 156. It says that A bails 100 bales of cotton marked with a particular rank to B. B, without A's consent, mixes the 100 bales with other bales of his own, bearing a different mark. Now, A is entitled to have his 100 bales returned, and B is bound to bear all the expenses incurred in the separation of the bales and any other incidental damage. Section 157 says that effect of mixture without bailor's consent when the goods cannot be separated. If the bailee, without the consent of the bailor, mixes the goods of the bailor with his own goods in such a manner that it is impossible to separate the goods bailed from the other goods and deliver them back, the bailor is entitled to be compensated by the bailee for the loss of the goods. Now it has an illustration that says that A bails a barrel of Cape flour worth rupees 45 to B. B, without A's consent, mixes the flour with country flour of his own worth only rupees 25 a barrel. Now B must compensate A for the loss of his flour. The fourth duty of the bailee is to return, that is, as section 160 mentions, return of goods bailed on expiration of time or accomplishment of purpose. It is the duty of the bailee to return or deliver according to the bailor's directions the goods bailed without demand as soon as the time for which they were bailed has expired or the purpose for which they were bailed has been accomplished. Further, Section 161 mentions bailee's responsibility when goods are not duly returned. If by the default of the bailee the goods are not returned, delivered, or tendered at the proper time, he is responsible to the bailor for any loss, destruction, or deterioration of the goods from that time. It has been held in the case of Dhyan Singh Sobha Singh vs. Union of India that when the purpose of bailment is accomplished or the time for which goods were bailed has expired, the bailee should return the goods to the bailor without demand. And if he fails to do so, he will keep the goods at his risk and will be responsible for any loss of or damage to the goods arising whatsoever. Now, termination of gratuitous bailment is another area. So, where the lending of the goods is gratuitous, the bailor may at any time require a return of the goods even though he lent them for a specified time or purpose. But if the bailee has acted on the faith of the loan made for a specified time or purpose in such manner that if the goods are demanded back before the agreed time, the bailee's loss would be greater than the benefits derived, the bailor must, if he compels the return, indemnify the bailee for the amount in which the loss occasion exceeds the benefits derived. Further, section 159 is as follows: restoration of goods lent gratuitously. Now, the lender of a thing for use may at any time require its return if the loan was gratuitous, even though he lent it for a specified time or purpose. But if on the faith of such loan made for a specified time or purpose, the borrower has acted in such a manner that the return of the thing lent before the time agreed upon would cause him loss exceeding the benefit actually derived by him from the loan, then the lender must, if he compels the return, indemnify the borrower for the amount in which the loss to occasion exceeds the benefit so derived. A gratuitous bailment is also terminated by the death either of the bailor or of the bailee. Section 162 says that termination of gratuitous bailment by death. A gratuitous bailment is terminated by the death either of the bailee or of the bailor. Now, talking about bailment by joint owners. Section 165 says bailment by several joint owners. If several joint owners of goods bail them, the bailee may deliver them back to or according to the directions of one joint owner without the consent of all, in the absence of any agreement to the contrary. So we see that the fifth duty is that of not to set up jus terti. So, as heard in Rogerson versus Lambert and Co., a bailee is not entitled to set up, as against the bailor's demand, the defense of jus terti. That is to say that the goods belong to a third person. Now, section 166 says that bailee not responsible on redelivery to bailor without title. If the bailor has no title to the goods and the bailee in good faith delivers them back to or according to the directions of the bailor, then the bailee is not responsible to the owner in respect of such delivery. But as held in Rogers, Sons and Co. versus Lambert and Co., The person who claims the ownership may apply to the court to prevent the bailee from returning the goods to the bailer and to have the question of title decided. Further, Section 167 mentions the right of third person claiming goods bailed. If a person other than the bailer claims goods bailed, he may apply to the court to stop the delivery of the goods to the bailer and to decide the title of the goods. And if the bailee has already delivered the goods to the person having a better title, and yet the bailer sues him, he may prove that such person had a better right to receive the goods as against the bailer. Now, the sixth duty is that of returning, that is, duty to return increase. So, in the absence of any agreement to the contrary, the bailee is bound to return to the bailer natural increases or profits accruing to the goods during the period of bailment. Further, on that note, Section 163 mentions bailer entitled to increase of profit from goods bailed. In the absence of any contract to the contrary, the bailee is bound to deliver to the bailer or according to his directions any increase of profit which may have accrued from the goods bailed. It has an illustration where A leaves a cow in the custody of B to be taken care of. The cow has a calf, B is bound to deliver the calf as well as the cow to A. As held in Standard Chartered Bank versus Custodian, where shares and securities were pledged with the bank and the bank received bonus shares and dividends and interest in respect thereof, it was held that the bank could not be compelled to hand over such increment unless the pledged securities were redeemed. Lastly, as a part of this lecture, I would like to discuss with you the idea of finder as mentioned under section 168. It says, right of finder of goods may sue for specific reward offered. The finder of goods has no right to sue the owner for compensation for trouble and expense voluntarily incurred by him to preserve the goods and to find out the owner. But he may retain the goods against the owner until he receives such compensation, and where the owner has offered a specific reward for the return of goods lost, the finder may sue for such reward and may retain the goods until he receives it. Section 169 says that when finder of thing commonly on sale may sell it. So, when a thing which is commonly the subject of sale is lost, if the owner cannot with reasonable diligence be found, or if he refuses upon demand to pay the lawful charges of the finder may sell it either when the thing is in danger of perishing or of losing the greater part of its value, or when the lawful charges of the finder in respect of the thing found amount to two-thirds of its value. So, finders are bailee too. For example, in the case of Isaac versus Clark, which was decided as early as 1615, finder of goods were held to be a bailee thereof and as such bound by the duty of reasonable care of. So he does not have the right to sue the owner for compensation for trouble and expense voluntarily incurred by him to preserve the goods and to find out the owner. Now, what are the finder's rights? So, Section 168 and 169, however, protect the interest of a finder in two ways. Section 168 allows the finder to retain the goods against the owner until he receives compensation for trouble and expense. Further, where the owner has offered a specific reward for the return of the goods lost, the finder may sue for such reward and may retain the goods until he receives it. Section 169 allows the finder to sell the goods in certain circumstances, where the thing found is commonly the subject of sale, and if the owner cannot be found with reasonable diligence, or if he refuses to pay the lawful charges of the finder, then the finder may sell the goods in the following two cases. Either when the thing is in danger of perishing or of losing greater parts of its value, or when the lawful charges of the finder in respect of the thing found amount to two-thirds of its value. With that, we come to an end to this given lecture. In the next lecture, we're going to continue with the same topic.